Hi everyone, and welcome, and thank you for joining us here at 42 Bedford Row for another of our seminars, which forms part of our spring and summer programme of online events. Today we're going to be hearing about some of the hottest topics in family law at the moment. In a second, I'm going to be handing over to our very own Francis Cassidy, who will be providing a guide to the recent Court of Appeal judgment in the case of Re HN. And what the future holds in terms of fact-finding hearings post that decision. And then Jennifer Youngs, also a family law barrister here at 42 Bedford Row, will be telling us about the provisions of the new Domestic Abuse Act and flagging which aspects of it are of particular interest to us family law practitioners. So Francis, over to you.
Thank you, Jeremy. And I hope everyone can just bear with me a minute while I share my screen with you. There is a PowerPoint presentation to go with the talk. Earlier this year, I gave a talk on a private law update, which looked at the practical issues arising from Practice Direction 12J in particular. And rather foolishly, I ended that talk by saying that I would prepare a talk once Re HN was available. Well, Re HN came slightly later than we all thought. The judgment was delivered on the 30th of March. And then, of course, my promise was taken up by Chambers. And here is my talk. The first thing to say about Re HN is that it didn't promise quite as much as perhaps we all thought it would, but in any event, it remains an important decision for those of us who practice every day, those of us who deal with private law cases every day. And I'm going to look not only at the individual appeals, but I'm also going to look at the guidance that the court saw fit to give in relation to some areas of the law. As you'll probably all know by now, there were 4 conjoined appeals, and they all raised issue in relation to allegations of domestic abuse in private law proceedings. The court said it was giving general guidance about matters which commonly arise, but was careful to point out, as it so often does, that none of the appeals themselves purported to establish new law, nor to establish any legally binding precedent. That's not going to stop, I imagine, many practitioners from raising arguments arising from those appeals. The first appeal I'm going to look at was Re B&B. It's an appeal made against the making of a consent order where the father was granted contact. But the real meat of this appeal was that months prior, at a previous hearing, the judge had made some wholly inappropriate comments to the mother regarding potentially removing her child from her. His Honour Judge Scarrett had told the mother that a child may be taken from her, may be adopted, and that he may refer the case to social services. A consent order was reached months later, but the Court of Appeal said the impact of the judge's comments on a young mother must not be underestimated. It was argued for the other side that, in fact, the judge's comments have been overtaken by events. But the Court of Appeal said it's hard to see how the mother, faced with the prospect of a hearing in front of the same judge, would have felt herself to have retained any real negotiating boundaries around contact. And they could understand why the mother may have felt that she had little option but to settle the case. So the appeal was successful. The second appeal considered was Re H. The appeal was dismissed as being purely academic. In that case, His Honour Judge Tolson QC found an allegation of rape to be not proven, declined to determine allegations of financial and emotional abuse, and made an order that contact should take place. If that contact did take place, and it was both the mother's and the father's case, the contact should continue. In fact, the local authority involved the child wrote to the Court of Appeal to stress the importance of the child of continuing contact. And the mother's legal team were unable to tell the court in those circumstances what the purpose would be in remitting the case for a retrial. So therefore, it was quite a straightforward decision for the Court of Appeal. The appeal was dismissed as being academic. As a side note to that case, there was a further fact-finding hearing in the same proceedings. A different judge, in that case, Her Honour Judge Cox, found an allegation made by the mother of sexually inappropriate behaviour by the father was not true. Third appeal was Re T. In that case, the appeal was allowed. The trial judge, Her Honour Judge Evans Gordon, did not find allegations of anal rape to have been proved. The Court of Appeal refused to interfere with that decision. But the judge had made findings of violence on the part of the father, particularly significant findings the Court of Appeal felt, one of strangulation and one of placing a plastic bag over the mother's head. Within her judgment, the trial judge felt that this case was one where there was mutual abuse, and the Court of Appeal felt that she hadn't properly considered the seriousness of the father's behaviour or whether the findings established a pattern of coercive and or controlling behaviour. The trial judge found there was now no risk, and the Court of Appeal overturned that decision, stressing that the focus should have been on the pattern of behaviour from the father. The fourth appeal was Re H&N itself. That appeal was allowed against the case management order. The case management order was consequent on the trial judge, again His Honour Judge Tolson QC, having declined to make a finding of rape, having indicated that certain admitted incidents of abuse against the mother should not be taken into account. Again, the issue was whether the judge had properly looked at the pattern of control and abuse determined on the basis, in this case, of father's admissions alone. Court of Appeal held the trial judge had discounted the father's admissions, which were perpetrated over a significant period of time, and underestimated the significance both for the mother and the child. Within his judgment, the trial judge had commented that such allegations were increasingly common and that there were benefits to mothers who made such allegations. He referred to significant advantages. The Court of Appeal specifically said those comments were inappropriate and found the judge's analysis to be seriously flawed in many respects and allowed the appeal. I'll now turn to the guidance that I say can be extracted from the judgment. The first and most obvious point is that the binary analysis still applies, that either allegations are found to be proven or not, the burden of proof is on the parent making that allegation, and the standard of proof remains the civil balance of probabilities. The Court of Appeal accepted that trial judges discharge a great responsibility with risks arising on both sides of a decision. Went on to say that if in reality the abuse did occur, there's a lack of evidence to prove it, the court's subsequent orders may risk exposing the child and partner to further abuse. Conversely, if alleged abuse did not in fact occur, the court finds the allegation proved, orders significantly limiting the perpetrating parent's future relationship with their child may be imposed. Perpetrating in inverted commas there, of course. Well, this is the essential dilemma of courts and fact-finding hearings. So classic restatement of the binary analysis. The Court of Appeal went on to say that deciding whether or not to hold a fact-finding hearing is important, not straightforward. Again, on the face of it, a statement of what is obvious to most people involved in the family justice system. The court stressed the responsibility at an early stage of the proceedings decide whether or not it's necessary to conduct the fact-finding hearing, and if so, which of a range of allegations that may be before the court should be the focus of that exercise. Court accepted such case management decisions may not be straightforward, that they may have a long-lasting impact on the outcome of the case and the final orders that are or not made. To those who attend early hearings in these proceedings, they will know that at the early stage of the case, possibly the HEDRA, court has limited amount of information. The court has allegations strenuously denied or positively asserted on one side. There is case law, particularly F&G 2020 EWHC 2369, which shows what happens when courts don't get hold of this decision at an early stage. In that case, an appeal was allowed when no fact-finding hearing was ordered, and yet the trial judge went on to make factual findings not teed up in earlier orders. Court also stressed that not every case requires a fact-finding hearing, even where domestic abuse is alleged, and emphasizes it's critical to identify at an early stage what the real issue in the case is. Well, again, the judge is faced with allegations of domestic abuse. It's going to be very hard for a judge to say that, in fact, that's not the real issue in the case. Sometimes it might be obvious it's not, but all they will likely to have is a safeguarding report, an application, and possibly statements from both parties. The court doesn't really get to grips with how such decisions can be made at an early stage. We know courts take a long time to list a first hearing. We know CAFCAS take up to 40 working days to provide safeguarding report. And we also know that when an early hearing is adjourned, such as a HEDRA, there may be a substantial delay. Court of Appeal also set out, and this may be new guidance, though it supplements Practice Direction 12J, the factors to take into account when deciding whether there should be a fact-finding hearing. Court stressed, particularly paragraphs 16 and 17, Practice Direction 12J apply, and they stressed the use of the word necessary in those subparagraphs. The court's guidance was, as well as what's set out in the practice direction, in considering whether there should be a fact-finding hearing, number one, consider the nature of the allegations, the extent to which it or they are likely to be relevant in deciding whether to make a child arrangement order. Number two, the court should have in mind the purpose of the fact-finding hearing, to, in broad terms, to provide a basis of assessment of risk. Number three, give careful consideration to Practice Direction 12J 17 and necessity. And the court has to consider whether the fact-finding hearing is necessary and proportionate. CAFCAS suggested they could help by providing a separate report whether fact-finding hearing is necessary. I'm not sure how much more that would add to delay in proceedings. Court of Appeal went on to say and stress Practice Direction 12J remains fit for purpose. It was important they said that because it's criticised from different sides. It says that it sets out a step-by-step template that courts are required to follow. In my talk given earlier this year, and there is a copy of the handout on the website, I set out guides on all the different stages identified by Practice Direction 12J. That might be useful for anyone who wants to make particularly targeted arguments at all the different stages, Practice Direction 12J. The Court of Appeal says that training, together with a proper application of Practice 12J, largely ensures that errors in fact-finding hearings are the exception rather than the rule. It's not completely clear what findings judges receive at different levels. It may be that more information will be available upon that. Court of Appeal went on to highlight some of the current private law initiatives, particularly the Harm Panel report, which it said the Ministry of Justice is moving to implement. There is apparently a move to implement integrated domestic abuse courts. I haven't heard of any pilot projects. I looked online and it appears to me the major planks of these proposed courts are giving judges greater powers to decide on evidence, making special measures automatic, reviewing the principle of parental involvement, using barring orders instead of Section 9114, and inviting the Domestic Abuse Commissioner and Victims Commissioner to undertake some form of monitoring. The Court of Appeal also said that the private law working group's April 2020 report are starting to be piloted. Again, I couldn't find much information about those pilots. If there's anything that stands right at the center of the Court of Appeal judgment in Re H&N, it's the focus on patterns of behavior and coercive and controlling behavior. The Court of Appeal undertook historical review of the law. That made it plain this used to be much overlooked by the family courts. They say that the concept of coercive and or controlling behavior is central to the modern definition of domestic abuse. The judgment of Hayden J and F&M 2021, EWFC 4 is endorsed. It's being evaluated both for its analysis and its inclusion of Home Office guidance and relevant statutes. Court of Appeal say a pattern of abusive behaviour is as relevant to the child as the adult victim, so that they say a child can be hurt in a number of ways, and the examples are set out in the slide, where the behaviour is directed against the child, where it causes the victim of abuse to be frightened, creates an atmosphere of fear, or inculcates undesirable values, particularly in young boys. Trying, no doubt, to include some balance into the judgment, the Court of Appeal stressed that not all unpleasant behaviour is abuse. They said it's important to be clear that not all directive, assertive, stubborn or selfish behaviour will be abuse in the context of proceedings relating to the welfare of a child. Much will turn on the intention of the perpetrator. The Court of Appeal endorsed the approach in Riel 2017, judgment of Lord Justice Jackson, and he drew a distinction where the alleged behaviour doesn't have the character of harming, punishing, or frightening victim, and isn't designed to make a person subordinate. Because at the end of a trial, it may well be that this distinction is easy to draw once a court has examined all of the facts and heard evidence. However, again, when judges are dealing with this at an interim hearing with a HEDRA, when the consequence of these allegations might be to limit contact, courts may find themselves in a difficult position in being able to decide whether such a distinction exists then. Another well-reported feature of the Court of Appeal's decision in Rien is its disavowal of the use of Scott schedules as a means of pleading, particularly where a pattern of behaviour is alleged. It appears from the judgment that all advocates who presented arguments to the court agreed that Scott schedules had stopped being useful, particularly where a pattern of behaviour was set out, and also because there was a concern it produced a false portrayal of a couple's relationship. Everyone seemed to agree about the solution, about the problem. Solutions difficult to identify. There's lots of reference to use of narrative statements, and it may well be that narrative statements are now directed. It becomes the job of the judge at the pre-trial review to analyse the narrative statements and come to a decision then about what the real issues are. There will be cases before the courts now coming for fact-finding hearings which have been directed on the basis of Scott schedules without the patterns being identified. And there may be cases where judges at fact-finding hearing have to make pretty drastic decisions about the issues that are going before the courts. There's more guidance about the court's approach to controlling and coercive behaviour. The Court of Appeal accept judges will be faced with difficult case management decisions. The court's view was that the overwhelming majority of domestic abuse, particularly abuse perpetrated by men against women, is underpinned by coercive control. It's the overarching issue that should be tried first by the court. Again, the important point is the impact that such a finding may have on the assessment of any risk in continuing contact. Everyone's going to have to get used to this being a central issue at cases going forward, and it may well be the Court of Appeal's decision is a helpful corrective to the historical lack of focus on this that they identified within their judgment. Court of Appeal also say the situational analysis is of little or no relevance. Summarising it, the situational analysis says, yes, there was domestic abuse in these parents' relationship, but now that they've separated, the risks don't exist or they're very low, so there's no need to take domestic abuse into account. The Court of Appeal are not impressed by that analysis, particularly in the context of coercing or controlling behaviour. They say it's of little or no relevance in establishing a future risk of harm and should be considered old-fashioned and no longer acceptable. They go on to say that even in the case where the court is dealing with assaults, to try and discount the importance of that on the situational analysis runs the risk that such behaviour will manifest itself in some other more subtle manner so as to cause further harm. Again, dealing with patterns of coercive or controlling behaviour, the Court of Appeal said that it may not be necessary if that allegation is put forward to consider specific allegations. I'm worried about this because it puts someone who's putting forward allegations of domestic abuse in a difficult position. Do you proceed with the allegation of coercive and controlling behaviour, or do you proceed on the basis of the individual allegations? The Court of Appeal said that if particular factual allegations are so serious that they justify determination irrespective of any alleged pattern, then the court can still look at that. But the example they use is of rape. Of course, as we know, many of the allegations, important and significant allegations, are pushes, shoves, those kind of things. It almost reads as if the Court of Appeal is saying that they are not serious enough to be considered. The pattern of behaviour is put forward. That's my reading of the judgment. I rather expect that part of the guidance not to be followed. In my judgment, it puts any alleged victim into an incredibly difficult position, into which they should not be put. Underpinning that part and many other parts of the court's judgment was its concern about the court's resources. Some of us may think it's an improper concern. If one looks at the statistics, again this year, private law applications have risen. This is on top of a relentless tide of previous increases. The court's resources are not increasing. There are not more judges, there are not more courtrooms available. The President had stressed on a number of occasions in his road ahead that the court has to deal with the necessary issues and that Practice Direction 12J should be read with the overriding objective. The President's also said there'll need to be a radical reduction in the amount of time the court affords to each hearing. But if the court is going to focus on patterns of controlling and coercive behaviour, it's inevitably going to take up more court time, not just a fact-finding or final hearing, but at the FHEDRAs, the DRAs, the directions and the review hearings. We all know there's an imbalance between the responsibilities of the court and the resources available. The court revisited the relevance of criminal law concepts. I say revisited because the Court of Appeal considered this a few years ago in the context of Kerr proceedings, and specifically disavowed the use of criminal concepts in family law proceedings. The court gives a good example of why this might not be a good idea. For example, behavior which falls short of establishing rape may nevertheless be profoundly abusive and should certainly not be ignored or met with a finding to not guilty in the family context. Agreed, that seems to be common sense. However, in what's now become the well-known case of JH versus MF 2020 EWHC 86, where Mrs. Justice Russell dealt with an appeal, which from His Honour Judge Tolson QC, where Mrs. Justice Russell said the court was improperly informed on domestic abuse, and where she spent some time in her analysis dealing with the criminal concept of consent. In looking at that judgment, there has been no criticism of importing a criminal concept into a family case. And I rather think the conclusion should be sometimes they're useful, sometimes they're not, and one simply has to leave it to the individual courts. The court dealt with the issue of credibility, and particularly said that an individual does not have to be blameless to be the victim of domestic abuse. Again, this seems strikingly obvious, but it was a feature in the Re-HN case that the trial judge had seemed to have come to a binary choice between either the deeply controlling father or the deeply troubled mother with mental health difficulties. The Court of Appeal were not impressed by the judge's analysis, and it said it goes without saying that the individual does not have to be blameless to be the victim of domestic abuse, and that the focus on the mental stability of someone putting forward allegations was wrong and flawed. The court said a consideration of credibility necessitates a wide consideration of all of the circumstances. The court set out again the classic approach to appeals against fact-finding. Most who work in this area will be familiar with Piglouser and G&G. That sets out the classic evaluation of the trial judge's role in evaluating the facts, of the full allowance that will be afforded to the trial judge, and of the reasons why the court will be slow to interfere with a trial judge's judgment. It's one of the most difficult tasks to advise people on whether they might be able to bring a successful appeal against a fact-finding judgment. What at least 3 of these appeals show is that with focused and well set out arguments, findings can be set aside on appeal. Beyond that, there isn't any clear guidance on which case might be successful, but there is at least encouragement to those who are usually put off. Returning to B&B, it's clear that the impact of what judges say can be important and relevant. It's as well, I think, to focus again on what the judge had said to a young mother in that case. Quoting from the judgment, if this goes on, the child will be taken into care and adopted. Court of Appeal says it's hard to imagine a more serious and frightening prospect for any mother, and they referred to it as a procedural irregularity which justified the appeal, and they referred to the anxiety that the mother much have felt. What they don't do is make any reference to whether there's been any complaints or disciplinary procedures taken with respect to that judge. I have in mind recent Court of Appeal judgments where the court's been happy to criticize social work managers, for example, but then we don't know what's been done with this judge or other judges to make sure that something similar doesn't happen again. And lastly, the court set out the proper approach to academic appeals. It's set out here within the slide. Essentially, one has to show that the appeal will make some difference to the order that the court is going to make. That this can involve a difficulty where findings are made which will have ramifications for a parent in the future. That argument on my ring authorities is sometimes successful and sometimes not. But in the context of this case, the court found there was a completely academic appeal and they weren't interested in it. That's the end of my talk. As I've made reference to my earlier talk this year, both handouts will be available on our website soon. The next talk that will be given by 42 Bedford Row will be a financial remedies talk on the 2nd of June by Jeremy Hall. I'm now going to hand over to my colleague Jennifer Youngs, who's going to address you all on the Domestic Abuse Act. Thank you very much for listening to my presentation. I'm now going to hopefully get myself off the screen and we can hand over to Jennifer.
Thank you, Francis. Hopefully you can all now see me. And I am indeed going to address the Domestic Abuse Act, which was at the time of re-HN still the Domestic Abuse Bill and was referenced within that judgment. You will see as I go through it that it doesn't address specifically fact findings in the way that perhaps had been contemplated at that time. I also say at the outset that as a significant caveat, much of this is not in force and there is no commencement date that has yet been set. So what I intend to do is simply set out what might be some interesting points which are raised by that Act and think about how that might impact upon family practitioners, particularly in private law disputes. And the first thing that the Act does is it sets out on a statutory footing a definition of domestic abuse for the first time. And that is what has received a lot of notice in the press, is that this is now in law and sets out a definition. And it doesn't differ significantly from that which is already in Practice Direction 12J. It's set out a bit differently, but its substance is very similar. What might be of particular use to family practitioners is that there is specific reference to the fact that conduct towards another person can constitute abuse towards another. So, for example, if it's towards someone's child. And also at Section 3, there is an explicit recognition of children as victims of domestic abuse if they see, hear or experience the effects of that abuse and they are related to either the victim or the perpetrator. And that, of course, simply confirms what was already set out in re-HN. In terms of the substantive measures which are set out in that Act, I note what was said by Francis about special measures in any integrated domestic abuse court. And indeed at Section 63 of the new Act, there is in effect a presumption that a victim of domestic abuse will have the benefit of special measures in a family court. The test sets out that that person would need to be at risk of being a victim or has already been determined to be a victim of domestic violence. I raise that because, of course, as has already been identified, these issues will often arise very early in proceedings and, of course, prior to any fact-finding hearing, because that's when you would need the special measures. And therefore, how it's going to be established that someone is at risk, for example, of being a victim of domestic abuse is an interesting point, and it's not yet set out how that test will be met. Throughout the Act, there are relevant reference to regulations which are going to be made and which will supplement it. Those provisions have been are brought into force already, and so perhaps they will provide us with some more detail as to what that will mean. But of course, if that test is set too high, it's going to severely limit the efficacy of these provisions in terms of ensuring that victims of domestic abuse are able to appropriately engage in court proceedings. And there's a similar provision as regards civil proceedings, which can be found at Section 64. And again, that will be relevant because, for example, Talata proceedings would fall under the remit of the civil court, In that context, it's not a presumption, but simply a provision that rules must be made and put in place to ensure that such special measures can be implemented. One of the significant parts of the Act is in respect of cross-examination in family and civil proceedings. And that again has been the subject of much comment as the bill went through, it made its way through Parliament, because that, as will be known to anybody who practices this kind of law, has been a very real issue for some time. The current law as it stands, and as will remain the case until the relevant provisions have commenced, is set out in PS and BP, which is 2018 EWHC 1987, in which Mr. Justice Hayden set out what he termed a forensic life belt until a rescue craft in the form of parliamentary action arrived. In essence, what that sets out is that at this stage, there isn't any presumption against cross-examination of an alleged victim by the person they make allegations against. And there's a need to consider, amongst other factors, the need to ensure fairness to both sides and to ensure that any cross-examination wouldn't be abusive and cause further harm. And in practice, as again will be known, I'm sure, to many of you, what would happen is that anyone who is unrepresented would put their questions in writing, and those would be put by a judge. And what the Act makes provision for is, in effect, a prohibition on such cross-examination by a litigant in person in a set of circumstances which are defined by the Act. Those include circumstances, for example, where someone has been convicted, charged or cautioned with a specified offence, when an on-notice injunction is in place, and also where specified evidence is adduced that someone is a victim of domestic abuse. That prohibition is in respect of both the victim and the alleged perpetrator. So if both were unrepresented, it would prohibit cross-examination in both circumstances. But of course, the reality is that it's more often the person who has been accused of abusive behaviour who is unrepresented. What will be particularly interesting to note is how specified evidence is defined in the regulations, and how high a hurdle that is will determine really how useful that particular provision is going to be. It's unclear if, for example, it might require similar evidence as would be required to establish eligibility for legal aid, whether that evidence would need to be from a professional, whether it would need to be in a witness statement. All that is unclear at this stage. There is a further provision within the Act, which I will term a catch-all provision, which requires the court to consider the quality of the evidence and if that would be diminished if a direction prohibiting cross-examination were not given, or if significant distress would be caused if cross-examination took place. Again, the regularity with which such a provision would need to be employed is going to depend on what specified evidence means in those circumstances, and the regularity with which a judge would need to apply that test is going to depend on the same. And it will be interesting to note how that test is applied, and if in fact the situation reverts back to something similar as in PS and BP, and if similar factors are applied. However, what is new is that there will be circumstances where the court is prohibited from allowing cross-examination by a litigant in person. And then, of course, there will need to be a way forward in those circumstances. And what is set out is that if the litigant in person does not have a qualified legal representative to act for them, one will be appointed by the court. Now, that is akin to the situation that's already in place in the criminal jurisdiction under the Youth Justice and Criminal Evidence Act 1999. And similarly to that regime, it's clear from the Act that any advocate appointed will not be responsible to the party for whom they have been appointed. That's an interesting and also perhaps ethically difficult position for that advocate to be in, because you're of course not instructed by that person, and it's not clear from the Act to what extent the advocate would see the papers, to the extent they would, if at all, be able to take instructions, and to what extent they're in fact running a case rather than simply cross-examining a witness. And of course, again, at this stage, we don't know what that regime will look like. But for anybody interested, particularly in this issue, the Bar Council have provided a guidance document in the context of the Youth Justice and Criminal Evidence Act under court-appointed legal representatives, which gives some idea of the issues which might be encountered in those circumstances. And it will be very interesting to see how these provisions work going forward, and if they do indeed solve the problem which has been apparent for some time, as was set out in PS, as regards the issue of unrepresented litigants in the family court. There are also similar provisions as regards civil proceedings, which are set out in the next section of the Act after the family proceedings rules are set out. Moving on then to the next, and I think that the final most significant amendment made by the 2021 Act, and that is domestic abuse protection orders. Now, at the outset, what the Domestic Abuse Act doesn't do is repeal any of the provisions of the Family Law Act 1996. So we will still have non-molestation and occupation orders. So what is not clear on the face of it is what these orders are intended to add and to what extent they're intended to replace the other protective injunctions under the Family Law Act. On an initial reading, it's clear that the orders under the 2021 Act are wider in their scope, in the sense that both the victim and the alleged victim, the police, or any other person with the leave of the court, or person specified in regulations, again, which have not yet been made, could also make that application. That's similar to the previous regime of domestic violence protection notices and orders, which the police could apply for. And this regime will supplant that previous legislation. So it does open up the possibility that these kinds of orders could be applied for example, by a domestic abuse worker or perhaps a social worker or someone of that type. It's not clear, for example, if a family member may also be able to apply and how wide this scope will really be. And it's interesting, perhaps, for example, in the context of public law proceedings, where you might, for example, find a local authority inviting a parent to make an application under the Family Law Act, if in fact this legislative regime might make it easier, in fact, for the local authority to make that application itself, rather than, for example, inviting the court to do that of its own motion. In terms of the test to be applied, the relevant factors to be considered are set out in section 33 of the Act, and it doesn't appear that that will make a significant difference in practice to the test to be applied under the Family Law Act, although again that is not yet clear. Breach of such an order would be a criminal offence and arrestable, as in the case of a non-molestation order. And it's clear that those orders could be made without notice. What is of particular interest is that a domestic violence protection order would allow for mandatory requirements, so that the subject of the order would be required to do something, and the court would have the power to nominate a suitable person to monitor compliance with that order, and they would have the power under section 36(2) to report that non-compliance to the police. And that would include, for example, requiring somebody to leave a property at which they live. Now this is particularly interesting, I would say, because it raises the question of whether it's going to make it easier, for example, to apply for a without notice occupation order, in effect, and whether or not it would also circumvent the tests which are set out in respect of occupation orders, and particularly the balance of harm test, and consideration of other criteria such as housing needs and financial resources. Those are not specifically set out in the Domestic Abuse Act, whether or not they would be applied in the same way by the courts, it is again something we don't yet know, but is an interesting point that will no doubt produce case law in the future. It's also been suggested in the course of reading around the issue on the internet by, for example, the Transparency Project, that this mandatory requirement might also encompass attendance at courses, so something akin to DVIP. That would be certainly very interesting in the sense that it would seem to give, if that is true, the court the power to impose an order to attend such a course, breach of which would be monitored and then a criminal offence. That seems to me to be a somewhat draconian order, which might give rise to arguments under the Human Rights Act, for example, and would be perhaps slightly abnormal in terms of criminal offence. But it's certainly an interesting point to be considered in the future. The Act also makes provision for the family court to be able to impose an electronic monitoring requirement, which is again something that's more usually found in the criminal courts. So those are perhaps the most substantial amendments that the Domestic Abuse Act makes to the family law sphere. There are just a few other points which I will run through very quickly that are also of relevance. There is specific reference to Section 9114 orders, and it makes clear that such an order can be made if further applications would cause a child or another individual harm, making, I think, what is perhaps already an option as a basis for making that order in the case law clear. New offences of non-fatal strangulation and threats to disclose private sexual photographs and films with intent to cause distress, so perhaps more colloquially revenge porn, are also set out. And as has already been referenced, whilst it's not necessary to prove criminal offences in fact findings, it might be useful to be able to refer to the importance that Parliament has placed on those matters, if such allegations are pleaded as part of a fact finding. There's provision for a report on the risk of domestic violence and other harm in the context of contact centres, which is unfortunately not due till 2023, so we will have to wait particularly some time for that. Section 77 places Clare's law on a statutory footing. And finally, Section 80 prohibits the charging for evidence of domestic violence from medical professionals, which may assist clients of those present when they're trying to make applications for legal aid. That we do know the commencement date of, and that will be the 1st of October of this year. So that was a very swift run through of the provisions of the Domestic Abuse Act, which I hope has been interesting and of assistance. Thank you very much for your time in listening to me do so. I'm now going to go back again to Jeremy, who's going to conclude and confirm what 42 Bedford Row are doing in the next few months. So thank you again, and I'll hand over to Jeremy.
Thanks so much, Jennifer, and also to Francis for those very interesting and timely talks. We're hoping to put the notes up on our website soon, and the recording of this talk will be posted on our YouTube channel too in a day or two, hopefully. Our next talk, as flagged by Francis, is a talk from me, Jeremy Hall, about recent cases and developments in the world of financial remedies. That's at 5 p.m. on Wednesday, the 2nd of June. And if that interests you, and you're forgiven if it doesn't, please come along to that. We'll be sending out the link soon, and keep an eye out on our website and in your emails for the future talks which we've got lined up. So thanks so much again for coming. Hopefully we'll see you soon, and have a great evening.